FIRPTA withholding in New York in the United States, taxes are typically involved when it comes to real estate transactions. American citizens who sell their property usually have to pay capital gains taxes on the profits they earn. Likewise, foreign investors can also anticipate significant fees. If you are a foreign investor in the U.S. dealing in real estate or income-generating stocks, you are likely familiar with the Foreign Investment in Real Property Tax Act, FIRPTA. Understanding FIRPTA withholding. The Foreign Investment in Real Property Tax Act, FIRPTA, is a federal legislation in the United States enacted in 1980 to impose a tax on foreign persons who sell or dispose of any United States real property interests. FIRPTA's main purpose is to ensure that foreign sellers pay the required taxes on the gains realized from selling real property in the United States. The Internal Revenue Service, IRS, defines real property interest to encompass not only land and buildings but also any interest in a domestic corporation unless it is established that the corporation was not a United States real property. Holding corporation, USRPHC, during the 5-year period ending on the disposition date or during the period of the foreign person's holding. Key provisions of FIRPTA: withholding tax obligations, exceptions and reduced withholding amounts, withholding certificate application, reporting and payment obligations. Who is responsible for FIRPTA withholding? In a real estate transaction where the seller is a foreign individual or entity, the buyer is typically responsible for withholding the tax under FIRPTA. The buyer must determine if the seller is a foreign person or not, and if so, must withhold and remit the required tax amount to the IRS. In some cases, the real estate agent or other professionals involved in the transaction may also be responsible for ensuring compliance with FIRPTA. Withholding agent's duties. The withholding agent, typically the buyer or their designated representative, has specific duties to fulfill under FIRPTA. These duties include determining if the seller is a foreign person or entity, calculating the required withholding tax amount based on applicable rates, obtaining the necessary forms and documentation, and remitting the taxes within the specified timeframe. Additionally, the agent must inform all parties involved in the transaction about the withholding requirement. Applicable rates for withholding under FIRPTA. The general FIRPTA withholding rate is 15% of the total sales gross proceeds. However, there are exceptions under certain circumstances. For instance, if the property is being acquired for use as a personal residence, and the sale price is between $300,000 and $1 million, the withholding rate is lowered to 10%. Additionally, sellers can apply for reduced withholding or an exemption if they believe their maximum tax liability is lower than the required percentage. To do so, they must submit an application to the IRS and obtain a withholding certificate. Exceptions to FIRPTA withholding. The Foreign Investment in Real Property Tax Act, FIRPTA, is a United States tax law that imposes income tax on foreign persons selling U.S. real property interests. Under FIRPTA, the buyer or transferee of real property must withhold and remit a specific percentage of the amount realized on the disposition of the property as tax. However, there are exceptions to FIRPTA withholding, which are discussed in the following sections. Transferee's use of the property for personal residence. One significant exception to FIRPTA withholding is when the transferee plans to use the property as their personal residence. In this case, no withholding is required if the amount realized, the purchase price, is $300,000 or less, and the buyer or their immediate family intends to reside at the property for at least 50% of the total number of days the property is occupied during each of the first 2 12-month periods following the date of transfer. Non-recognition transactions. FIRPTA withholding does not apply to non-recognition transactions. These are transactions in which the seller does not recognize any taxable gain or loss due to specific provisions of the Internal Revenue Code, IRC. Some common non-recognition transactions include like-kind exchanges under IRC Section 1031. Contributions to a partnership in exchange for an interest in the partnership under IRC Section 7-21, and transfers to a corporation controlled by the person transferring the property under IRC Section 351. FIRPTA withholding certificate. A FIRPTA withholding certificate primarily serves the purpose of either reducing or eliminating the 15% tax withholding required under FIRPTA. The purpose of the tax withholding is to make sure that there are sufficient funds to cover any tax liability arising from the foreign person's sale of real property in the United States. However, the tax liability may be less than the 15% withholding amount, or the seller may be eligible for an exemption. In such cases, applying for a FIRPTA withholding certificate can be beneficial for the foreign seller as it can result in a reduced or eliminated withholding amount, thus releasing more funds at the time of closing the transaction. Application process for the withholding certificate. To apply for a FIRPTA withholding certificate, a foreign seller must complete and submit IRS Form 8-238B, Application for Withholding Certificate for Dispositions by Foreign Persons of U.S. Real Property Interests. The form should be submitted to the IRS before or on the closing date of the real property sale. It is also a good idea to submit the form as early as possible, as the IRS usually takes up to 90 days to process applications and issue withholding certificates. The effects of non-compliance with FIRPTA Withholding. The Foreign Investment in Real Property Tax Act, FIRPTA, is an initiative in the United States aimed at taxing foreign citizens who invest in or sell U.S. real property. Withholding under FIRPTA is crucial for both buyers and sellers to understand, since non-compliance can result in severe penalties from the Internal Revenue Service, IRS. Liability for tax, interest, and penalties. Non-compliance with FIRPTA withholding can lead to significant consequences for all parties involved in the real estate transaction. If the buyer fails to withhold and remit the required tax amount to the IRS, they may be held liable for the tax, along with any accrued interest and penalties in relation to that tax. This is particularly concerning for the buyer because they are responsible for withholding the tax from the amount paid to the foreign seller. Failure to withhold penalty. One of the key consequences of non-compliance with FIRPTA withholding is the failure to withhold penalty. This is a penalty imposed by the IRS on the buyer when they fail to correctly withhold the required tax amount on a real estate transaction involving a foreign seller. The penalty is assessed at a rate of 20% of the required withholding amount, with additional interest accruing from the date of the transaction. Importance of filing necessary tax returns to avoid non-compliance with FIRPTA withholding and its consequences. Both foreign sellers and buyers of U.S. real property must understand their respective tax obligations and make sure they file the necessary tax returns timely and accurately. Don't leave your financial future to chance. Contact us today at 212-729-4090 to schedule a consultation and secure the professional advice you need to thrive in the U.S. real estate market.